Hello, cybersecurity class, and welcome to class 6 in our class on cybersecurity and national security. In this class, we're going to talk about the law of emergencies and how that law might apply to a cyber emergency. You'll have to excuse my voice. I have a little bit of a cold, and hopefully my voice will hold up and we can get through the lecture. So we have talked quite a bit throughout this semester about early debates before the adoption of the Constitution and even after the adoption of the Constitution about the scale and scope and use of national military force. And one of the big concerns, of course, was that the federal government would use a large standing military to impose a state of tyranny. Very early on, the first tax that the United States imposed on a product was a tax on whiskey, and that caused a large number of people in the frontier states to kind of rebel against that tax, to stage some acts of insurrection, and it's called the Whiskey Rebellion. And at that time, President Washington had to invoke something called the Calling Forth Act, which allowed the president to call forth the militia of the states. He called forth a militia of about 10,000 men from various states who actually marched into Pennsylvania with Washington at the head of this group of militia to put down this rebellion. There weren't actually any shots fired. The rebels packed up and went away before this force came, but it illustrated this difficult question of the federal government intervening in issues of the states. Of course, we saw the biggest example of the federal government getting involved in affairs of the states in the Civil War. Now, of course, the southern states in the Civil War claimed to have seceded from the Union and to have formed a separate political sovereign, which was a claim that the Union always rejected as being unlawful. So during the Civil War, as we've talked about a little bit in class, there were a number of issues about executive power, including President Lincoln's suspension of the writ of habeas corpus to detain Confederate prisoners. And then, of course, after the Civil War concluded, there were huge issues about the federal government enforcing the laws that gave rise to Reconstruction in the South. So, of course, the South had been utterly economically and infrastructure-wise devastated by the Civil War, and there were efforts to rebuild the South, but to rebuild the South in a way that recognized the freedom of the newly freed former slaves, African Americans living in the South. And of course, there were the Jim Crow laws and other efforts in the South to essentially keep otherwise free blacks from really living out their freedom. And as part of that, the federal government had troops stationed in the South to help with some of these efforts. Now, at some point, there was a disputed presidential election, which was the election of President Garfield in the late 1800s, and as part of a compromise to settle that dispute, the federal government agreed to withdraw the troops from the South, and the end result of that agreement is the Posse Comitatus Act of 1878. So the Posse Comitatus Act is a statute that forbids the use of federal troops in the states except under certain conditions. So it reflects a strong view that the federal government should not deploy military troops into issues that otherwise would be considered the police powers of the states. Now, we can kind of move rapidly through history up through World War II. And of course, World War I and then World War II were very large-scale mobilizations of the nation because of the event of war. And after World War II, Congress significantly reorganized the military and significantly reorganized the National Intelligence Services through the National Security Act of 1947. Now we kind of move up from World War II into the Cold War, and at the start of the Cold War, the Korean War. And the beginnings of the Korean War provide the backdrop for the Youngstown sheet and tube case. So at the outset of the Korean War, there was a large-scale steelworkers union strike. President Truman saw this as potentially compromising the war effort because steel has to be used to make ships and tanks and other things like that. And so President Truman sought to force the steelworkers to terminate their strike. And President Truman did not have a specific congressional authorization to do this, but was trying to exercise what he saw as his inherent power as the commander-in-chief in a time of national emergency or war. Now, Truman had not gotten a formal declaration of war against Korea from Congress, although there was a United Nations authorization to take military action in Korea. So this case goes up to the Supreme Court, and as you can see in the pieces of the case that I gave you to read, it is decided by a highly fractured Supreme Court. Now, the end result of the plurality is that the court found that President Truman lacked the inherent authority to order the steelworkers to go back to work. So absent some specific congressional reason to do so, President Truman couldn't do that in his role as commander-in-chief or under any other inherent authority. The really important opinions for you to look at are really Frankfurter and Jackson's opinion. Now, Frankfurter's opinion is interesting, I think, just because of a couple of good quotes, good principles that are contained in the opinion. Jackson's concurrence is really the one that most international law and national security law scholars will look to as a framework for how to think about inherent presidential powers. So Frankfurter's concurrence, you can see this quote here on the screen, this idea of the accretion of dangerous power doesn't just happen in one day, it kind of comes slowly, and it's not quite a slippery slope, but more like the frog in the kettle kind of thing. And if it isn't checked, it will simply continue. And Frankfurter notes that it is not the case that Congress never gets involved in these situations, that Congress numerous times since World War I, Frankfurter said, had specifically granted to the executive a certain kind of authority to do something like intervening in a strike. But when it did so, or to seize economic production, but when it did so, it contained very specific limitations, which are not the case when the president is acting under some inherent authority. So then we get to Justice Jackson's concurrence, and Jackson's concurrence is really the key one that we use as a framework. And as you can see from Jackson's concurrence, he looks at sort of three general areas in which the president might try to exercise some kind of authority over state-level kinds of events. So the first one, Jackson says, is when the president has an express or implied authorization from Congress. And here Jackson says that the president's authority is at its maximum. And to hold the president's action unconstitutional in that kind of setting would really be to say that the federal government as a whole lacks some kind of authority to act. And it would place a very heavy burden on the person attacking that action to try and show that. Essentially, you'd have to be showing that the government was acting contrary to some constitutional guarantee, like a guarantee in the Bill of Rights. So the middle zone, Jackson said, is when the president is acting in the absence of a specific congressional grant or denial of authority, and the president is acting within his own independent powers that the Constitution gives him. And here Jackson says there's a zone of twilight. So a nice little piece of language there, a zone of twilight. And so there's perhaps, if the Congress hasn't acted, this invites some independent action by the president. But notice the last sentence, this is going to have to be really tested pragmatically. If this is going to be challenged in court, we're going to have to look at the particular imperatives of events and contemporary imponderables. rather than on abstract theories of law. So the third area, Jackson says, is where the president takes measures that are incompatible with the express or implied will of Congress. And here Jackson says the president's authority is at its lowest ebb. He can rely then, Jackson says, on his constitutional powers minus whatever constitutional powers Congress may have over the matter. And he says the courts in those cases would only be able to uphold what the president is doing by saying that Congress actually lacks the authority to act. And so here the court would have to conclude that the presidential power is so conclusive and so broad that it's clear. And if it's not that clear, then it has to weigh against saying that the president has the authority to act. So that framework is still a framework that we will often employ and use when we're looking at the question of whether the president has the authority to act in relation to some claimed inherent power like the president's inherent war powers. Now, as we kind of move up through our historical timeline, we've been talking about World War II and then the Youngstown case at the start of the Cold War and the start of the Korean War. And then we kind of move up through the Cold War era and through the Vietnam era, and we've talked a little bit, as we talked about the FISA statute last week, about some of the congressional actions in the wake of the Vietnam War. And the National Emergencies Act is another example of congressional concern about the possibility of government overreach, executive overreach, and executive secrecy in the face of supposed emergencies. And in particular, the National Emergencies Act resulted after a congressional study of states of emergency that had been declared and that had remained in existence. And one of these went all the way back to the New Deal era in the 1930s, and it also included the Korean War and some others, so that there was essentially a perpetual state of emergency. And there was concern that even given the framework in the Youngstown case, that a president might use some existing state of emergency to kind of perpetually extend a suspension of the ordinary rule of law, the ordinary separation of powers. Now, another piece of this backdrop, and I use this word suspension of the rule of law, which I think is really important, because we normally think that we are governed by the ordinary rule of law, the ordinary constitutional guarantees, the ordinary legal guarantees that protect our rights as citizens and that limit the ability of the government to intrude to a certain degree on our personal affairs. Now, there's always a recognition that in some circumstances of exigency or emergency, that the government may need to act for the greater good in ways that impinge on some of our individual or personal rights. But there's always a tension there, because the emergency can create such a hole and such an ongoing hole in the ordinary rule of law that we might even say the rule of law as a whole is suspended, and that really we're not operating under law anymore. We're operating under a sort of dictatorship or a set of emergency powers that strip away most of our rights. And of course, when you have discussions like this, you don't want to invoke Hitler on any kind of regular basis, but a lot of the concern did arise from the fact that Hitler's rise to power and what Hitler did in Germany, and in particular what Hitler did in Germany with the Holocaust, was a result of a suspension of the German Weimar Constitution under an emergency powers provision that effectively gave Hitler's government near absolute power before and throughout the course of World War II. So, and of course we can speak of many other examples. We mentioned in class the example of Julius Caesar marching into Rome at the head of his army. All those kinds of examples are very relevant to this question of whether the ordinary rule of law governs or whether some emergency governs. So as you see from reading the National Emergencies Act, what it tries to do is impose some very specific limits and reporting requirements on the executive for when an emergency can be declared, for how long an emergency, state of emergency can last, for requiring reporting and ongoing congressional authorization in the case of federal action in a state of emergency, and requiring a specification of what authorities are invoked and are suspended in the case of a state of emergency. So now, continuing to move up through our timeline, we have gone from the Whiskey Rebellion through the Civil War, through World War I and II, through the Cold War and the Korean and Vietnam Wars, and now we get to our sort of current age, which is the age of the War on Terror. And so, as we've talked about, again, in connection with FISA and the Patriot Act and other things throughout this class, 9/11 changed everything, and it had a very significant impact on how we think about this backdrop of national security issues. I think you could see the kind of pendulum swing back and forth. At the time of the founding and at the time of the Revolutionary War, the pendulum was kind of swung toward limiting federal power and limiting the ability of the federal government to invoke an emergency, although it did exist. The Civil War, a kind of maximum of federal authority. Reconstruction and some of the disputes about Reconstruction, and after Reconstruction, maybe a little bit of a swing back toward the states. World War II, World War I and World War II, a swing back toward the government, and then maybe that expanding up through the Cold War, but then in the wake of the Vietnam War, a swing back a little bit the other way, maybe toward more accountability. And then, of course, 9/11, perhaps a swing back toward the expansion of the ability of the government, federal government, to kind of be involved. And maybe now, with some of the Edward Snowden revelations, some swing back or push back, although I think we're in a bit of a gray area right now. So I think it's interesting to see how those events affect how we understand these relationships under the Constitution and under the law. So, of course, one of the big developments after 9/11 was the creation of the Department of Homeland Security. And the Department of Homeland Security is created by the Homeland Security Act of 2002. The Homeland Security Act of 2002 is really the biggest reorganization of the federal national security apparatus since the National Security Act after World War II. So if you think of the kind of seismic event that World War II was in terms of the reorganization of legal and practical military and law enforcement authorities, another seismic shift after the Homeland Security Act. I also gave you a piece of the torture memo, the so-called torture memo, to read. And if you recall, this is a memo. It was an internal government memo laying out the ability of the U.S. government to use what some call torture and what others call active interrogation techniques on some of the suspected terror prisoners. And as you read that memo, and I really wanted to give it to you as, in my opinion, a kind of cautionary tale about the practical implications of thinking about the scope of presidential power and the scope of what a state of war or emergency allows the executive to do, and what the scope of a state of war or emergency allows the government to do in relation to what we might otherwise think of as human rights. And of course, as you read that memo, it's famous or infamous for arguing for a very wide scope of authority to use a wide variety of forced interrogation techniques. So this brings us to the discussion of Hamdi V Rumsfeld. And Hamdi V Rumsfeld is a constitutional challenge that reaches the Supreme Court to the detention of terror suspects at Guantanamo Bay. And those persons detained at Guantanamo Bay were being held without a criminal trial or any other kind of adversarial proceeding, and were being held without access to the writ of habeas corpus. So habeas corpus literally means I have the body, and it's kind of a very ancient, so to speak, procedure guaranteeing that an individual who's detained on suspicion of a crime has some opportunity to actually have some kind of hearing or trial. The government can't just hold somebody forever simply on an accusation, but has to actually eventually prove whatever claim is being made against the person. And I've seen the practical implications of this. I've had an opportunity a couple times to take trips to Haiti and visit a law school that our law school has in the past worked with in a rural part of Haiti. And one of the issues, and we actually visited a prison that is in the town of Jérémie, Haiti, where this law school is, and things were better the last time I was there. But in the past, and in many parts of Haiti still today, you can be detained on sort of any kind of accusation from a neighbor or something like that, or just because the police don't like you. And you can be held in prison for years and years and years and never really have a trial and actually just die in prison. So it's a common technique of sort of corrupt governments, petty tyrants, and dictators and the like. So the writ of habeas corpus is a very important procedure and guarantee and principle that you can't be held forever. You have to be tried. So anyway, this issue gets brought up to the Supreme Court, and one of the key issues in the case is, well, we have here not just kind of ordinary criminal charges, but we have, the government claimed, we have enemy combatants who were taken prisoner during a time of war, and that the executive has the inherent authority under the president's war powers and specific authority under the Congressional Authorization for the Use of Military Force, or AUMF, that authorized the president to go after the terrorists who perpetrated the 9/11 attacks. So you can see the different opinions in this case, and it's very interesting to see the different justices and how it breaks out. In O'Connor's majority, she says the AUMF authorizes the detention, but not an indefinite detention. So at some point, there needs to be some kind of hearing. The hearing doesn't necessarily have to be a full-blown criminal trial, but it has to be some kind of hearing. But nevertheless, the AUMF did give the president the authority to detain these suspects. Now, Justice Scalia, who of course was the court's most famous originalist, writes a dissent, and interestingly joined by Justice Stevens, and Scalia and Stevens, of course, didn't usually agree on too much. But Scalia says that unless the suspension clause is invoked, a criminal trial in federal court would be required for these detainees. So what is the suspension clause? It is in Article 1, Section 9, which places some limits on Congress, and it states that the privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it. So this would require some specific congressional finding that there was a need to suspend habeas corpus, and presumably it would only be for a limited purpose and a limited time. Justice Thomas, writing in dissent, now Thomas is also supposed to be an originalist, and so here again we see Scalia and Thomas disagreeing about what the original meaning of the Constitution is. But Thomas states that the executive has the inherent power in the time of war to detain indefinitely those who are designated as enemy combatants. So how does all of this relate to our subject of cybersecurity? Well, as we've been talking about all semester, the trend is toward the cyberification, if I can use a term like that, of warfare, of terrorism, of crime. And it's just a result of the fact that so much of our lives are done in and depend on cyberspace. And it's also part of the fact that cyberspace is really so vulnerable. And it relates back to the very first module in our series of these classes on internet governance, and the fact that it's tough to figure out how, if at all, the internet really is governed, and who, if at all, has responsibility and authority to secure it, or to come up with rules relating to conflict in that space, and so on. So the U.S. federal government, of course, has thought about this long and hard. And early on, and this was a report that was done for President Obama a number of years ago now, on the risks of cybersecurity, and one of the conclusions of that report was these two words, which I think are kind of ominous words: regulate cyberspace. Regulate cyberspace. So really kind of strong, interesting statement that the United States has a economic and strategic national interest in asserting some kind of regulatory authority over cyberspace. And it raises this, difficult problem that we've been dealing with since the beginning of the Internet Governance module, which is, how do you safeguard critical infrastructure and vulnerable people while maintaining the Internet as the unique open forum that it is? Now, in the Youngstown steel seizure case, there was kind of a paradigmatic example of where the executive sees an important national resource or facility that is being compromised in relation to a war effort or an emergency, and the executive wants to step in and take control of it. We saw the same thing, of course, during the Reconstruction era, with the federal troops literally stationed on the soil of the southern states in order to try and facilitate Reconstruction and protect the black citizens of the United States in the South. And we see that constant tension, and we see that reflected in the Posse Comitatus Act. We see it reflected in the National Emergencies Act, and so on. Well, within cyberspace, there has been an effort over the past 5 or 6 or 7 years to create some kind of national federal legislation that would require some specific kinds of regulation on the internet. And one of the main concerns of those proposed pieces of legislation was, well, what authority does the federal government have in the event of a serious attack or emergency? An attack that disables or damages a large part of the internet, or a cyber attack that threatens public safety, like an attack on the power grid or the water supply or something like that, that's facilitated by cyber means. And one of the early proposals was in a bill called the Cybersecurity Act of 2009, which did not pass, but it was a proposal that would have given the president the authority to declare a state of cybersecurity emergency and to order the limitation or shutdown of internet traffic. And this provision pretty quickly in the internet law community was dubbed the kill switch, the internet kill switch. Now, of course, I think it's impossible actually for anyone to implement a kill switch on the internet as a whole. It's just technologically probably not possible. But it certainly is possible to attempt to shut down or disable portions of it. We've seen this happen, and we see it happen repeatedly in other parts of the world where there are popular insurgencies against dictators. We saw it in Egypt against President Mubarak in what was at that time called the Facebook Revolution, because the organizers of the revolt against Mubarak used Facebook and other means of social media to help organize it. And Mubarak's government tried to shut down the internet. It's one of the very first things they tried to do. Now, of course, the situation in Egypt has developed in some really difficult ways, but nevertheless, I think the example of the fact that the internet is used to facilitate resistance to dictatorship, and that one of the first things that governments try to do to retain control is to shut down the internet. I think that's still true. So the kill switch was widely resisted, and this provision was not adopted. And in fact, we have not yet had comprehensive federal cybersecurity reform. A number of efforts were made after this 2009 effort to come up with some kind of comprehensive legislation, and they all sort of progressively watered down the ability, the express ability of the president or the federal government to declare an emergency or to shut down the internet. Although, very interestingly, the Obama administration continued to argue that the president already has inherent authority to shut down the network under the Communications Act of 1934. And it's a very kind of complicated argument. I've actually written a whole article about it if you're interested in it. But there is an argument to be made, I think a weak one, but an argument to be made that the Communications Act of 1934, which originally governed radio and telephones, could authorize the government to, at least in certain areas, take control of the communications network that we now call the internet. Now, you may be aware of the broader dispute about President Obama's use of executive orders to implement policies that the administration favors that for one reason or another have not been implemented by Congress. And one piece of that is this area of cyberspace and cybersecurity. And there are a number of executive orders that President Obama did issue in relation to cyberspace that would have been pieces of some of these cybersecurity statutes that have not passed. One of those is Executive Order 13636 on improving infrastructure. Another relates to financial transactions. Another relates to information sharing. And in fact, the information sharing piece, in a sense, has become moot because Congress did just pass an information sharing bill, which the president did sign into law and which will become effective very soon. And then another executive order about being able to block transactions of people who allegedly are involved in cybercrime. Now, I think to a significant extent, there's nothing deeply controversial in the text of any of these executive orders outside the broader debate about the use of executive orders. Even the critical infrastructure one really only adopts some voluntary compliance standards. It doesn't put any mandates on any companies to adopt certain levels of cybersecurity. But I do want to point out one provision from one of these executive orders, which is that the president states that because of the prevalence and severity of malicious cyber-enabled activities, the president declares a national emergency to deal with the threat. Now, what does this declaration of a national emergency do? It invokes inherent presidential powers, and it invokes presidential powers specifically under the National Emergencies Act to take certain actions that might otherwise not be in line with the rule of law. So you should know that, at least according to one of these executive orders that the president has signed in the past couple of years, that we do presently exist in a state of national cyber emergency. And this, I think, brings us back around to one of the basic legal and policy questions that I find most difficult and most interesting when we're talking about cybersecurity and national security, which is, where does cyberspace fit in to our traditional concept of the constitutional separation of powers? So we have here, of course, the executive, the White House, the Congress, and the judiciary, our traditional separation of powers. And of course, we would add onto that, not formally but informally, the sort of so-called fourth branch of the administrative state. But formally, of course, we have these three branches. And in particular, how does the check of the judicial branch work, and how does the check of the legislative branch work when we're dealing with cyberspace? What role does the judiciary have in approving and checking things like surveillance and search? Does the existing framework under the FISA statute really create a meaningful judicial check? What role does the judicial and the legislative branch have in relation to the presidential power to declare a state of emergency, to possibly take control of the network or portions of the network, and or to engage in activities that might be considered acts of espionage or acts of war, like the Stuxnet virus? Does cyberspace create a new domain that is so new and so transcendent of national borders that we need to think in terms of a governance structure that goes beyond our framework of the nation state, and within the United States, our constitutional framework of the separation of powers? Or can our existing framework adapt sufficiently to deal with this? Lay on top of that history. Where are we in history now? Has the pendulum from the post 9/11 world begun to swing back a bit because of the Snowden revelations? Are we in a place now where we need to think again about some of these restraints? Are we seeing, for example, in the FBI's obtaining of an order to get into the iPhone used by one of the San Bernardino terror suspects and that whole dispute? We'll talk about that a bit more in class. Are we seeing there some of that pushback, or not? Is public sentiment and is the necessity such that we need to continue to have the pendulum swing between these sort of areas of liberty and security towards security? Those are the big questions I'm going to leave you with, and that we're going to talk a bit more about in class tomorrow.